Welcome to another episode of Lunch with the Shark. Join us as we dive deep into discussions about business, accounting, and finance to help you build a business that thrives. Now sit back and have a bite with your host, the Shark CFO, Vidal Espinosa.
Hello, and good afternoon. Welcome to a new edition of Lunch with the Shark. I am your host, Vidal, the Shark CFO Espinosa, and I am really happy that you guys are here with us this afternoon, this Thursday afternoon. Damn, I don't know where the day has gone. Look who we have behind us. It's Captain Crunch, and he actually decided to go to bed and sleep with Master Yoda. Yes, Captain Crunch, he loves his Star Wars like us. So I'm really happy that you guys are today. So let's actually dive right into the topic, because I want to apologize that we told you guys that we were going to talk about multi-level LLCs. Nevertheless, after reviewing this topic, I thought that it was very, very specialized and a bit complex, because this is a not a strategy, but this is a multi-layer protection. This is a multi-layer strategy that big conglomerates utilize. They even go offshore and things like that. So I think it's a little bit not out of our league per se, but I think this is just very particular topic. But what we are going to do is we're actually going to talk about the different types of entities, documents, because what I want to do is I want to show you that registering your entity, it's not everything that you need. Hire a service company like LegalZoom, Rocket Lawyer, and companies like that will charge you $99 plus filing to open, and I quote, open your LLC, your corporation, your partnership, your nonprofit. That's not what having or creating an entity entitles. So I want to show you that by doing that, you're actually just registering the company. You're actually just creating one of multiple steps on opening your company. You're actually being unprotected. You are not fulfilling the objective of the creation of the entity. And what you're doing is you're just exposing yourself at the time of a lawsuit, at the time that probably an employee files a unemployment claim or files a unfair firing with the labor board. And the only thing is hey, let me go to Google and let me download a template that you don't even know if an attorney has created. You have no idea where it comes from. And let me just change the company name to my name. So we're going to talk about that, because I think that this is more important. This is really, really interesting, that you must know what does a corporate documentation folder must include. So as we begin to look at how these documents affect the operation of various types, it is important to pause a moment on the idea of ownership and control. You might not think that these documents are important, or you might think that just download them because all of them should be the same. No, let me download them from Google. Well, that's not the case. Okay. How can you demonstrate your ownership if you only have your birth certificate? In the state of California, the birth certificate of a company, which is for a corporation, articles of incorporation, and for an LLC are called articles of organization. In no place, members or shareholders are stated or mentioned in those documents. Therefore, how can you establish ownership and interest, controlling interest in those entities? Please tell me. So, depending on which type of business structure and entrepreneur you choose, the concept will manifest themselves in different ways. The ownership and control of business typically begins when some sort of agreement between owners or founders and management. Generally, owners might tend to be different than your managers or your board. Okay, it's very interesting because I think it was yesterday we were talking about this issue. 2 or 3 years ago, I actually was supporting one of our clients process or obtain a business license with the USDA, which they regulate the import and export of food, of grocery, of fruits and vegetables. Okay, so the first application that we submitted, it came back as not denied, and I was like, why was that approved and denied? Well, I took the phone and I called the office, and they actually transferred me to the director of the area for what we were seeking the license for. And he says, oh, yes. I recall the application. So let me pull it out, he said. And he says, as a matter of fact, I have a couple of the inspectors who review the application with myself, and we came to the conclusion that since the owners were not managing or operating the business, we cannot grant the license. So I paused for a minute and I said, and replied to his comment, I said, you know what? Let me just ask you this question. I said, do you think or do you believe that Bill Gates, one of the owners, listen to this, one of the owners of Microsoft, is he always at any given time working or visiting every single Microsoft store that there is in the United States? I immediately heard crickets coming from the other side of the phone. He said nothing. And I said, the owners of this company hired managers to manage their interest and their business in the United States. So I clearly demonstrated to him the difference between owning a company and managing or operating the company. Guess what? The license was approved immediately after that comment. The problem here is that most of us assume that owners should be and or are managing and operating the business. Remember, what are we? Are we business owners, entrepreneurs, or are we self-employed business operators, independent contractors? Aha. Okay. So ownership agreements usually concern following fundamentals. Number one, control of the entity or the authority to act on behalf of the entity in carrying out business activities. Which person or persons has the authority to make business decisions and enter into legal agreements on behalf of the company? Who? Is it the owners, or is it the managing members, or the managers on an LLC, or the board of directors, your executive level in a corporation? Percentage of entity ownership. If the company is jointly owned by more than one owner, the agreement should define each owner's total ownership share. Do you have that? Is it written? Or is it, oh, it's my compadre, how the hell he's going to screw me? Let me tell you. Number 3, entitlement to profits and responsibilities for losses. Who stands to make money if the business goes well? And just as important, who bears the responsibility for any debts if the business does not grow? Is it clearly stated? Do you have it clearly marked? Or did you just download it, a template, or did they provide you a template just to fill in certain spaces with your business name? And did you even read it? Did they even go over those items? Each type of business entity will have an inherently different relationship with regards to management, operation, and ownership. Do you listen to those 3 words? Management, operations, and ownerships. Depending on which type of entity you choose for your company, you will answer to the questions above will vary. Yes, control, percentage of entity ownership, and profits and losses. Those 3 questions. Obviously, on a sole, remember which were the 4 legal entities to which we spoke a couple of ways ago? Sole proprietorship, partnership, corporations, and LLCs. Okay? Remember, I am not an attorney. I am not providing legal advice. You should seek an attorney that will clarify every single document that we are talking about. I am not providing legal advice. I am just telling you, based on my experience, what I've seen, heard, done. Okay? So, a sole proprietorship, it's actually the most basic of business operations. Remember, a sole proprietor has only one owner. Issues of control or ownership operations are mute. There's nothing. It's just you. Hey, Vidal, you are opening a business? Yes, I am opening a business. Hey, who owns it? You own it? I own it. Yes. Sole proprietor. It's in the. I am the sole owner. So I have 100% of the profits. Unfortunately, I have to swallow 100% of the losses. Okay? I can designate myself to operate it and to manage it. Period. Do you agree? I agree. I second it. Okay, motion passed. You see, I'm a sole proprietor. That's simple. It doesn't even have to be in writing. I just give myself permission, and that's it. Vidal, do I have my permission? Yes, you have my permission. Perfect. God bless you. Go on. Carry on. That's simple. Nevertheless, I have no protection whatsoever. Period. No protection whatsoever. Partnerships. Entering into business partnership can be challenging and rewarding experience though. In the best partnerships, each member complements the other, creating a whole that is greater than the sum of its partners, meaning that everybody brings in something to the table. Okay? So, In order for a partnership to operate at its best, experts advise that each partner collaborates on the crafting of a partnership agreement before the business gets started. Not when we're in business, not when, oh shit, we have an issue. Oh shit, I need to open a bank account. Oh shit, we need to rent an office space and they're asking us for the partnership agreement. Oh shit, we've been sued. And no. Before you start the business and you have decided that the best structure would be a partnership, you create this document. These documents to which we are mentioning, they are actually the rules of the game. You are not going to sit down, and let me give you an example. Miguel Angelito, the baby shark, he loves playing Monopoly. But guess what? The rules to the game, to that board game, have been already preset. They are agreed upon starting the game. We don't change them at the middle of the game. We don't change them when we first roll the dice. Not at all. The rules of the game are already there in place and we follow them. So in business, we must do that. We must be addressing those issues because a business is created to generate wealth. And when monies, dineros, hermanos, dineros are involved, you have to have very, very clear rules to the game. So the partnership agreement should outline each partner's control over the business, his or her ownership interest within the business, each partner's duties and responsibilities. In addition, the following are considerations to keep in mind when drafting a partnership agreement. Remember, you are not an attorney, neither am I, and you should not be drafting this agreement with a template downloaded from Google. I'm going to tell you a quick story that I encountered this morning. We're actually creating a tax strategy for one of our clients, and he does not like offshore strategies. So what we decided is like, okay, let's bring it onshore. Let's bring it to the mainland and strategize based on tax credits and the tax code. So we mentioned him a U.S. territory, okay, which they have a benefit if you establish your company there. So he said, oh, you know what? I found out that this and this act are the ones that you're referring to. And I said, you know what? Good for you. You're doing your due diligence, but you're wrong. You're wrong. I said, Google forgot to mention to you that those two acts don't exist anymore. They have been superseded by this act. He turned red. I don't know if he got upset or he got embarrassed. I said, don't be embarrassed or don't get upset. I said, you're doing your due diligence. Unfortunately, Google, it's not an expert in taxes. Seek expert advice and mute your ears to opinions and things that you do not understand. He proceeded to say, hey, would you recommend me any groups or things? I said, you know what? Don't try to do it on your own. I said, because you are not going to understand the terminology, the jargon that we have as accountants or tax preparers. I said, are you going to go to WebMD and diagnose yourself the sicknesses that you're having? Oh, I have runny nose. My eyes are watery. You have allergies. No, but WebMD says that you might have cancer. So what? Do you have cancer? Hopefully not, knock on wood. But people, don't do that. You're not supposed to be writing your own agreements. Don't download templates. So the agreements, a partnership agreements, should have governance. What are the core values, essentials to running the business? What rules should guide the course of the business, and what mechanisms can be created to make sure those are followed? Relationship. It is important to establish and define the business relationship that exists between partners. Duties and responsibilities. What actions will be expected of each partner? Most businesses fail, yes, because of lack of cash flow, but also for the lack of communication. We might assume that, oh, since we're 50-50 partners and I advise you on having 50-50 partnerships or companies or LLCs or corporations, because who's going to tie break any decisions? You're always going to end up with, oh, I don't want to do it, or I want to do it. Who the hell is going to tie it up? Never. 51-49 are more recommended. Fuck it. I have 51% and it's a yes. So duties and responsibilities, if you have no clarity on what partner it's going to do and the other, sometimes you're 50, 51, and 49, and you're doing most of the stuff and most of the work and so forth, you might resent the other partner. But if from the get-go you said 49%, but you put the capital, and I 51, and I work on the company, you might forget it because you might see that the other one is not doing anything and you are doing and busting your ass off, and hey, he's not doing anything and I'm getting 51% of the profit, blah, 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 blah. But it's in writing, dude. He put up the $1 million. You have to put 51%. Yeah, in work, right? Profits. How will profits be distributed among the partners? Dispute resolutions. Establishing a mutual agreement upon method of resolving possible problems before they arise. It's a vital part of maintaining a healthy relationship. You actually are setting the rules of the game before anything happens. These are the rules to the game. Do you want to change them? Let's go back to the drawing board and agree upon it. But in the meantime, this is what we agreed upon when we started the business. Dissolving the partnership. What happens when one partner wants to leave the business? Can I buy you? Does your spouse buy it? What? How is it going to be shared? How is it going to be transferred? Including if the possibility of selling off to a partner, selling off to a third party, or do we dissolve the partnership? Now, let's talk about limited liability corporations, LLCs. Okay? In some states, LLCs, in all of states, as far as I know, they are required to create an operating agreement. Remember, LLC birth certificate, it's called Articles of Organization. Okay? Now, LLCs, their rules of their game are called operating agreements. An operating agreement lays out the basic ideal governing the company and the expectation of its members. Okay? Remember, I'm teaching you here the words and some jargon when it comes to if you own an LLC, you have articles of organization, you have your operating agreement, and if you own it, you're a member. You're not a shareholder, you are a member. Okay? So, in an operating agreement, it lays out the basic ideal governing the company and the expectation of its members. Okay? In particular, operating agreement will define and must must define the following. Ownership. What is the ownership percentage of the profit and loss distributed among the LLC members? Authority. What are each member's duties and obligations? How does the LLC define voting rights? Governance protocols. This establishes rules for meeting and voting. Yes, even though it's an LLC, you must follow these protocols. Okay? Decision making. What are the rules of making business decision? Leaving the LLC. How does a member exit himself from a company? Dispute resolution. This establishes a mutual agreed upon method of resolving issues between members. If you see here, there's similarities so far between a partnership agreement and the operating agreement. Okay? The most important one is that we are setting the rules to the game prior to. As with the partnership agreement, many states have a default operating agreement that applies if the LLC does not create its own. And most likely, if there's a lawsuit or a dispute, you're not going to like what by default the state tells you, because it might not be what you and your member friends agree upon. But if it's not in writing, dude, and if it's not signed, which is the most important thing, that you have to sign it, okay? You have to sign it and execute it, okay? It's not valid. It's not valid. Okay? Now, let's go to the corporation documents, corporate entity documents. There are two types of operational documents required for corporation. There are two. Minimum two. The first one is the bylaws. Yes, the bylaws. Yeah, no, the ones that Rocket, I don't know, I forgot their name, LegalZoom and whatever those one will send you, and you just need to put in, you need to write in your core company name. That's it. Yeah, good for you. And the shareholder agreement. The purpose, now let me go back and tell you. The birth certificate for a corporation, it's called Articles of Incorporation. Okay? The owners of a corporation, Inc., they're called shareholders. The rules to the game for a corporation are called bylaws in general. Okay? Now, the specifics to those rules of the game called bylaws are called minutes of organization. That's where you agree upon specifics based on your bylaws. And lastly, the shareholder agreement, which means that it's all the agreements between the shareholders. The purpose of the corporate bylaws is to define the operating procedures within the corporation. Bylaws may cover a wide range of subjects, but at the very least, they should provide the following information: name, address, and principal place of business, a list of directors and corporate officers. Hello, they're different. They're not the same. They don't fulfill the same functions. Okay? They can be held by same individuals, but they're different. Directors and corporate officers. Okay? Procedures for the election and appointment of officers. It's not like, oh, my mom authorized me to be the CEO of the company. No, 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 no. No, 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 no. Okay? Terms of service. The amount of stock the corporation is authorized to issue. If you have not consulted with an attorney or a qualified business advisor and you're opening a corporation, does LegalZoom tell you how many stocks, number of stocks you should issue in the capital? Because that amount, it's stated in the articles of incorporation. Or are you just swinging it like, oh, you know what? I like number 7. I'm just going to put 7 shares. You can just only issue 7 shares. At what value? Oh, I am a real estate investor and I am going to have 7 shares at $7. Guess what? You only have $49 in capital. That's not well capitalized. Are you going to use $49 to buy property and flip it? How dare you? How dare you? It's only $99 that LegalZoom charges me. You're trying to charge me this much. Oh, my attorney, it's charging me $2,500 for the LLC, for the corporation. Oh my God. You immediately have Peter as a corporate bail. $49 for a real estate investment flipping company in capital? Is it enough to buy a house? It's not even enough to buy a gallon of paint. Be very careful. Rules of directors and shareholder meetings. What? Do I have to meet? Standards of corporate record keeping. Just write it there. Procedures of amending the articles of incorporations and bylaws. If you want to change the rules of the game, how the hell are you going to do it? It's not just as simple as saying, hey, you know what? I don't want to hold meetings every year. Really? Oh, we are going to not disburse any dividends over $250,000. Really? Okay. A shareholder agreement is a document drawn up among shareholders to define the specifics of their ownership and rights. These documents are not necessarily publicly filed, and the content may vary from company to company. It may not vary. It does vary from company to company. All these documents that I've mentioned, with the exception of the articles of incorporation and or articles of organization, are not public domain. They are internal documents and agreements that are executed between partners, members, or shareholders. And they are not public domain. So you should not be concerned that anybody out there will know the content of these documents. But let me tell you one thing. I've read court cases from the tax court where IRS has requested polygraph tests on shareholders and members to validate the dates where the agreements were signed. Remember, any court proceeding, you are under penalty of perjury. They might not get you on the taxes, They might not get you on certain chingaderas here and there, but they will get you on perjury. If you do not sign these documents prior to starting the business, and you sign them when you go to court or when you're in an audit or when whatever happens like that, you are lying. Or unless you tell them that you just executed those documents, then therefore the date when they were executed, that's when the date starts becoming valid, regardless of the document saying December 1st, 2001. It doesn't work like that. You must have those documents prior to starting your business. Consult with an attorney. These documents are not necessarily public. So in general, shareholder agreements must concentrate on the following issues: shareholders' eligibility, procedures if a shareholder leaves, dies, or you fire him or her, shareholders' rights and obligations, valuation of stock for internal purposes. Let's say that you want to buy off your one of your shareholders. How are you going to evaluate their shares? Entitlement or obligations to repurchasing stock. Information on the regulation of the shareholders' relationships. You tell me, do you think a template will be sufficient to keep your interest protected? Do you think investing on keeping you compliant, current, and protected, it's a good investment? Or just a simple question. Do you go ahead and knock on somebody's door where a sign of for sale there is, and you say, hey, I want to buy your house. Here's money. Just get out and give me the keys. That's it. Plain and simple. I paid him. He gives me the keys. They walk out. I walk in, and it's my house. Is it like that? No. You go and you do a procedure and you get the title and you get documents. And do you think they are templates? Do you think that there's specifics that they cover pertaining your situation? It's the same thing in your business. I said it today to a client. You know what? The basis to a successful business and a successful business tax strategy starts with your business structure. Starts with your business structure documents. If you're a corporation, how many shares are you going to issue? To whom? Who's going to be the director? Who's going to be the executive officer? Most likely, you're the only person in the company. Most likely, you're going to hold the chair to all of those positions. It does not matter. You must appoint yourself to cover those positions. If you don't have them, if they're vacant, they have to be mentioned. I have not hired a CFO. Here we are. We can hold that chair for you. Think about it. Makes sense. Invest. Be willing to invest in yourself, in your company. Okay. To find out when we release new content on YouTube, make sure to subscribe to our YouTube page. Jesus, take the wheel and play the video. To do this, search for Invictus Advisors in the search bar at the top of the YouTube page. Click on our YouTube page. On the right-hand side of the page, click the red subscribe button. You will now get notified about all the videos and the episodes of Lunch with the Shark that we uploaded to YouTube. So, to end up today's Lunch with the Shark, we're going to finish with a quote from an American-born British poet, T.S. Eliot, who he said, "Only those who will risk going too far can possibly find out how far one can go." Wow. Push yourself to the limits. But the limits are far beyond what you think you can go. Trust me. Trust me. One day, if I tell you a story, my story when I was kidnapped, I pushed myself beyond the limits that I was thinking that I was capable. Just think about that. How far you can go. And it's way, way, way farther than you think it is. It's great seeing you today. See you tomorrow. Madre, hoy vamos por ti. She is in the hospital. She had a little surgery and she's doing very, very well. So keep up the good work, Mom. See you later on today. We'll pick you up. Bon appetit. Ciao.
Thank you for listening to Lunch with the Shark. If you would like to set up a consultation with the Shark CFO, Vidal Espinosa, visit his website www.invictus-advisors.com and don't forget to subscribe on Facebook, Instagram, YouTube, Twitter, and LinkedIn.